Hi, I'm Firearms Attorney Gilbert Ambler. In our last video, we talked about how the incoming Attorney General in Virginia, Jay Jones, who does not take office, by the way, until the middle of January 2026, how he is trying to, at least in my opinion, unconstitutionally involve himself in a firearms rights case that was going on in Virginia over the past several years and which has hopefully finally reached a conclusion in Virginia. Today, we're going to have some updates on that situation. We're going to talk through the responses of the parties, and the parties, I mean the parties currently in the case, which is VCDL, GOA, an individual who brought a challenge against the law. We're going to talk about the other party to the case, which is the Colonel of the State of Police, represented by the current sitting Attorney General. And then we're going to talk about the intervener, which is Jay Jones, somebody from the outside trying to get involved. And finally, we're going to talk about what the Court of Appeals of Virginia has to say about all of this entire mess that is taking place and turning into a constitutional fight that does not have to happen. But before we dive into this, as always, if you have not yet hit that subscribe button, what are you waiting for? Hit subscribe, like, comment with your thoughts, and share with your friends. That way, you and your friends can keep getting this important Second Amendment related information. Now, as a reminder, this case involved Virginia's universal background check law. It's been going on since 2020, October 2025, late October 2025. We get a decision from a circuit court judge in Lynchburg that strikes the law down as unconstitutional. That decision did not go into the merits of background checks as a whole. So he did not decide background checks as a whole were unconstitutional. He didn't decide that the potential delays were unconstitutional. So we didn't get that deep in the weeds. All he said was because this law failed to consider how it would prohibit 18 to 20-year-olds from acquiring handguns, and because 18 to 20-year-olds have gun rights, it is unconstitutional, and he struck down the law as a whole. The deadline to appeal that decision was the beginning of December 2025. And December 1st, 2025, which is when the deadline expired, no appeal was filed. At that point, Jay Jones filed a motion for extension of time to file an appeal, which, as we described in the last video, was really more of a motion to intervene. He's asking the court, can I get involved in this, even though I am not yet the Attorney General? So a quick update on this situation. At this point, both of the parties, both the current Attorney General, and when I say the current Attorney General, he's the one representing the Colonel of the State, the Superintendent of the State Police in Virginia, and GOA, VCDL, that combination of plaintiffs, have both filed with the court responses. The Colonel of the State Police, Superintendent of the State Police, I'd have to go back and I use those terms interchangeably. The Superintendent of the State Police for Virginia, represented by the current AG, his response basically said exactly what we would expect, which is, why are we even looking to somebody who's not yet in office? This was my decision to make. We've made that decision. The party is currently represented, and we elected not to appeal. Nothing further to see here. And really the interesting thing there is not saying that this would have been a likely outcome, but there was potentially a small part in the back of everyone's minds that thought maybe the appeal didn't get filed due to inadvertence with the shifting administration, knowing that he's leaving office. Maybe they just didn't think about it and missed the deadline and actually would have wanted to appeal. Their response on this makes it very clear. They did not intend to appeal. They did not want to appeal. Thank you very much, Jay Jones. You've got nothing to say about this. Then the plaintiffs responded as well, and the plaintiffs filed a much lengthier brief. Similar to the Attorney General's brief, they made it clear there's only one Attorney General at any given time, and that is Jason Miyares at the moment, and until mid-January, Jay Jones has nothing to say. I'm going to actually quote for you for just a minute from some of what they had to say. He said, in stark contrast, so they described how the power to execute the office of Attorney General is with the current and sole elected Attorney General. And then they go on to say, in stark contrast, the so-called Attorney General-elect is no constitutional officer at all. Indeed, Jay Jones' self-styled title appears nowhere in Virginia law. What is the self-styled title? It's Attorney General-elect. Thus, the Attorney General-elect holds no constitutional or statutory power, and he has no duties to perform at this time. He is the chief executive officer. Again, they're quoting from his briefing, from Jay Jones' briefing. He is the chief executive officer of nothing and has no authority to represent the Commonwealth or its interests in any litigation. As a legal, rather than a political vernacular term, the Attorney General-elect is a figment of J. Jones' imagination, no more powerful or duty-bound than the ordinary citizen. The point here, and what VCDL and GOA is saying very succinctly with that, is you've got no more power than the average Joe in this situation to get involved. Sure, you become AG in the middle of January, but that does nothing for you right now. Now, here's where it gets interesting. J. Jones, of course, had a responsive filing, and in the responsive filing, again submitted by that outside DC law firm, because he is, of course, not yet in office, he very breathlessly talks about the important public safety considerations and why the Court of Appeals should give him an extension of time to represent the interests of the Commonwealth of Virginia. And the Court of Appeals has actually responded and has invited the parties to, and when I say the parties now, the Court of Appeals is including J. Jones in this, has invited the parties to submit briefing on other cases in which, for one reason or another, someone in the legislature sought to intervene in the defense of a law. And so these would be cases. A great example is a case out of North Carolina where there was a law that was passed. It was a voting redistricting law. And in that case, the governor tried to veto the law. There was then a General Assembly override of the General Assembly's veto. So probably, and I'd have to look at North Carolina law to see how this was accomplished, but normally 2/3 voting majority to override the veto of the governor. Law goes into effect. There is a challenge to the law brought, a constitutional challenge, and the people that were sued in that was the governor and the attorney general, both of which did not like the law and did not want to defend it. In that case, the legislature that had overrode the governor's veto said, we want to be involved in this lawsuit, intervened, and ultimately at the end of the day were allowed to intervene based largely on a statutory provision in North Carolina that said the General Assembly has an interest and can get involved in defending the law. That's not what's going on here at all. What's going on here, of course, is the law was defended by the sitting attorney general. It was found to be unconstitutional, and he elected not to further appeal that decision. Of course, the Court of Appeals has yet to make up their mind on this. I was hopeful that it was going to be a very quick and easy decision for the Court of Appeals and that they would summarily, without any further briefing, tell J. Jones, sorry, you're not the current Attorney General. You've got nothing further to say on this matter. Apparently, they are not going to make it that quick and easy. They have invited this briefing. And of course, we'll keep an eye on where this goes, because if the Court of Appeals grants this motion for an extension of time, we know that we will be in for a very rough 4 years in Virginia, because J. Jones is not even in office yet and is seeking to get involved and infringe on gun rights and court decisions that say gun laws are unconstitutional. So it's going to be a lengthy process indeed. If you enjoyed this content, go ahead, hit that subscribe button for us. Until next time.